Motion passed. Rural Representative Election Legislation Amendment Bill 2013.
We now resume the second reading debate on the Securities and Futures Amendment Bill 2013. Mr. Ka-keung Lam, Chairman of the Bills Committee on the above bill, will address the Council on the committee's report. Mr. Ka-keung Lam. Mr. President, as Chairman of the Bills Committee on Securities and Futures Amendment Bill 2013, I table the Bills Committee's report to this Council and report on the work of the committee. The bill seeks to amend the Securities and Futures Ordinance (SFO) to provide for a regulatory framework for the over-the-counter derivative market (OTC) derivative market in Hong Kong and to incorporate other improvements for the regulation of the financial market. The Bills Committee has held 9 meetings to discuss with the administration and met with deputations for views on the bill. The administration includes the SFC as well, and the Bills Committee has also received 12 written submissions from deputations. Members support the legislative proposal to provide for a regulatory regime for the OTC derivative market in Hong Kong, which aims at reducing counterparty risk, improving overall transparency, protecting against market abuse, and ultimately enabling regulators to better assess, mitigate, and manage systemic risk in the OTC derivative market. The Bills Committee also notes that deputations are supportive of the proposal. They believe it will strengthen Hong Kong's competitiveness as an international financial center and enhance the stability and liquidity of the OTC derivative market. They've also made various suggestions to improve the operation of the regulatory framework. The Bills Committee notes that the new regime for the OTC derivative market will be jointly overseen and regulated by the HKMA, Hong Kong Monetary Authority, and SFC, with HKMA regulating the OTC derivative activities of authorized institutions, AI, and approved money brokers, AMBs, whilst SFC will be regulating such activities of licensed corporations, LCs, and other prescribed persons. The bill sets out the regulatory framework with details prescribed in the rules to be made under SFO by SFC with the consent of HKMA and after consultation with the Financial Secretary. Such rules are subsidiary legislation subject to the negative vetting procedure of the Legislative Council, as the details of the regulatory regime and the requirements will be set out in subsidiary legislation. The Bills Committee and deputations urge the administration to prepare the detailed rules for consultation with the stakeholders as soon as possible. Members also consider it necessary for HKMA and SFC to align the requirements of the regulatory regime with international standards to minimize the compliance cost on market participants. HKMA and SFC have stressed that they will strike a balance between strengthening regulation and reducing impact on the industry. They will also continue to liaise with overseas regulatory bodies and engage the local financial services industry with a view to facilitating the smooth implementation of the new regime. They've also expressed that they're preparing the draft rules taking into account the relevant international standards, regulations, and rules of other major jurisdictions. They plan to consult the public in the first half of this year. The monetary reporting, clearing, and trading obligations and requirements applicable to prescribed persons are set out in the new Part 3A of SFO. The subsidiary legislation will specify the types of OTC derivative transactions which are reportable. On monetary trading obligation, the administration will further study local market conditions before deciding when to implement it. On mandatory reporting obligation, the Bills Committee notes that the prescribed persons are required to report the reportable transactions to the Trade Repository, HKTR, developed by HKMA. As OTC derivative transactions are global in nature, the Bills Committee has expressed concern about multiple reporting on OTC derivative transactions to regulators of various jurisdictions, which would increase the compliance costs on the industry. The administration has responded that HKTR will assist HKMA and SFC in having effective and efficient access to OTC derivative transaction information to ensure the effective surveillance and monitoring work. HKTR is linked to major global TRs. Prescribed persons can then trust global TRs to file reports to HKMA on their behalf. HKMA has been in close contact with reporting agents that are global trade repositories, advising them the essential information and contributions required from them. The Hong Kong Trade Repository is an electronic system for keeping information and records of OTC derivative transactions. The Bills Committee notes that for greater clarity for HKMA to recover the cost from reporting entities for the use of HKTR, the administration will propose CSAs to add the new section 101 KA of SFO to provide for the power of HKMA to charge the relevant fees. The authority has also pointed out that the HKMA will charge the fees on a cost recovery basis. It plans to consult the public on the proposal in the first half of this year. The Bills Committee notes that the prescribed persons will be required to clear certain OTC derivative transactions through a designated central counterparty (CCP), as a mandatory clearing obligation can be discharged either directly or indirectly. The bill proposes to extend the coverage of the insolvency override protections so that they also apply to defaults of the recognized clearinghouse RCH itself and the agreements and arrangements between the members of the RCH and their clients. Also, in future, any collateral, margin, or guarantee fund contributions deposited with an RCH will be regarded as falling within the scope of market collateral and are thus covered by the insolvency override protections. The Bills Committee has examined how the new Section 42A work in extending the insolvency override protections. SFC has explained that by bringing such client clearing arrangements within the definition of default rules, it will provide a legal certainty that the positions and collateral of the client will not be included among the assets of the defaulting OTC client clearing service providers. In the case of default, they can be ported to another service provider or disposed of, and the balance returned to the client. Under Section 41 of SFO, the rules of a recognized clearinghouse would have to be approved by the SFC, and the relevant international standards also required a CCP to ensure that there is a high degree of legal certainty as regards the enforceability of its rules in the case of insolvency. Hence, the bill protects the assets of clients of indirect clearing. To better clarify the extended coverage of the insolvency override protections, the Bills Committee notes that the administration has taken on board the Hong Kong Stock Exchange's suggestions on the technical drafting of clauses 57 to 60. The administration will move CSAs to clarify the meanings of certain terms and improving the drafting of provisions. The Bills Committee supports the administration's proposed CSAs in this respect. The Bills Committee has noted that there was no specific reference in the bill to the record-keeping requirement. However, after observing the approaches taken by other major overseas jurisdictions, the necessity of having a separate record-keeping obligation has become apparent, so that adequate records are maintained to evidence compliance with the mandatory reporting, clearing, and transaction obligations. The regulatory authority can access these records in carrying out their regulatory functions. Details of the record-keeping obligation will be set out in subsidiary legislation. The administration will move CSAs to add a new Section 101DA and make consequential amendments under Clause 9 to this effect. The administration has supplemented that they had conducted soft consultation with the industry, including the Hong Kong Association of Banks in early this year and they have no objection. The Bills Committee supports the amendment. The Bills Committee notes that in response to market feedback, the administration will move CSAs to the proposed sections 101B, 101C, and 101D to expressly clarify that even if a transaction contravenes the mandatory reporting, clearing, trading, and record-keeping obligations, this would not affect the validity and enforceability of the transaction. The Bills Committee understands that the amendment is included to avoid any doubt or uncertainty and is consistent with the approach taken in other jurisdictions. The Bills Committee supports the proposed CSAs. Apart from the prescribed persons, the bill also provides for the oversight of these SIPs, systematically important persons, as their positions and activities in the OTC derivative market are so large that they may pose potential systematic risks. The Bills Committee is concerned how SIPs are identified, the information to be collected, and disclosure of information. The administration explains that a quantitative approach will be adopted, taking into account the industry's views, that is, the SIP thresholds. Any person whose OTC derivative positions reach the thresholds should notify SFC. Setting thresholds will facilitate understanding by market participants, enhance efficiency of the notification process, and keep the calculation for the assessment simple. The administration points out that the information collected must be sufficient to ensure effective oversight. Public disclosure will be limited to the name of the SIP and specific class of OTC derivative transactions in respect of which the notification level has been reached. The Bills Committee is concerned about the impact of the new regime on regulated activities RAs under SFO and OTC derivative service providers now acting as intermediaries. The administration explains that Schedule 5 to the bill to SFO will be amended to include two regulated activities, namely Type 11 RA to cover activities of OTC derivative transactions involving dealers and advisors. Also, the bill also will add a new Schedule 11 to provide for the relevant matters. Now, in relation to asset management, Type 9 RA and Type 7 RA providing automated trading service, it will be expanded to cover OTC derivative portfolios and transactions respectively. In addition, the bill will also add Schedule 11 to provide for transitional arrangements for the new and expanded RAs. The Bills Committee is concerned how the transitional arrangements work in minimizing disruption to the market. The administration has advised that the purpose is to allow serving intermediaries in the OTC derivative market to continue their businesses for a limited period of time while their applications to be licensed or registered for the new or expanded RAs are being considered by SFC. This would facilitate market players to ease into the new licensing regime with minimum disruption to their existing businesses, as well as facilitate the winding down process or the transfer process for corporations who may not wish to or are not able to apply for the new or expanded RAs. In response to the feedback from the public consultation, the administration has supplemented that both the application and transitional periods have been lengthened to 3 months and 6 months respectively. On the Bills Committee's concern over the fees to be paid by applicants, SFC has responded that applicants are required to pay application fees upon submission of the applications, which may be regarded as the annual fees for the first year from the deeming date. The annual fees, once collected, will not be refunded to the applicants even if the applications are subsequently rejected. This is consistent with the current practice of regular license applications. If the applications could not be determined by SFC within 1 year from the deeming date, the applicants concerned will need to pay the annual fees for continuing to carry on the new or expanded RAs in the second year. The Bills Committee notes that HKMA and SFC will be given the necessary investigatory and disciplinary powers to oversee and regulate activities in the OTC derivative market. They would also share with other regulators information relating to the transactions regarding OTC derivative products. The Bills Committee is concerned about the investigation process of SFC and HKMA and the rights and protections for persons under investigation. SFC has explained that the persons under investigation or a person providing assistance to the investigation will be issued with a notice for production of records or documents, which will include a list of records or documents the person is required to provide relevant to the investigation. SFO also contains provisions to ensure SFC's investigations to be conducted fairly without prejudicing the legal rights and protections afforded to the persons under investigation. The provisions include Section 187, claims against self-incrimination, and Section 380, subsection 4, the common law right to legal professional privilege. On the proposed amendments to Section 186 and the new 186A to SFO, the Bills Committee is concerned about the factors SFC and HKMA will take into account in providing assistance to regulators outside Hong Kong investigations into activities relating to the OTC derivative market. The administration has advised that Section 186, subsections 3 and 4, and the proposed Section 186A, subsections 7 and 8, provides the conditions for assistance to overseas regulators and the factors SFC and HKMA must take into account, including the interest of the investing public, the public interest, and whether the assistance will enable the counterpart regulators to perform its functions, whether the counterpart will pay for the costs, and whether they will provide reciprocal assistance to Hong Kong. The administration has been requested by the Bills Committee to consider imposing a precondition for the overseas regulators to provide reciprocal assistance before SFC or HKMA gives the assistance. Some Bills Committee's members have urged the administration to consider providing a list of overseas regulators to whom assistance will be provided in subsidiary legislation and subject the matters to the negative vetting procedure of the Legislative Council. The administration has stressed that it is a common practice for international regulators to take into account reciprocity before giving assistance, but it is not a common practice to make it a mandatory precondition. The administration has pointed out that SFC and HKMA at present have entered into Memorandum of Understanding or bilateral cooperation arrangements with the relevant overseas authority in respect of their functions. SFC and HKMA may also give investigatory assistance to an overseas requesting authority that has no formal agreement with them, as long as all the requirements set out in Section 186 and the proposed 186A are fully satisfied. The administration stresses that it is important to retain this flexibility because it usually takes time to enter into a formal agreement, whereas it is desirable to be able to offer and receive investigatory assistance in a timely and efficient manner. As for disclosure of information by HKMA to SFC and overseas regulators, including information in the HKTR, the Bills Committee is concerned about the protection of privacy of parties involved in OTC derivative transactions. The administration, HKMA, points out that given that mainly institutional players such as banks, LCs, and funds are involved in OTC derivative transactions, information kept by TR would include data relating to individual OTC derivative transactions conducted by these institutions, such as the types and amount of derivative transactions, their economic terms, and the counterparties concerned. The Bills Committee also notes that the HKTR explicitly requires that no personal data should be reported. In compliance with the Personal Data Privacy Ordinance, the HKTR sets out its policies and practices with regard to personal data to be collected from the private individual in a personal information collection statement. Some members of the Bills Committee has urged the administration to make a list of overseas counterparts that could be to whom the HKMA could disclose information in the subsidiary legislation and subject the matter to negative vetting. The administration has explained that the purpose of publishing the names of overseas persons under Section 381FA or F4 is to enhance transparency. Given that the International Regulatory Committee is working together to ensure smooth and effective access to TR data to enhance transparency, the administration is of the view that subjecting the disclosure mechanism to a negative vetting procedure may create uncertainty in terms of mutual access to TR data and jeopardize the cooperation arrangement HKMA seeks from other jurisdictions. Moreover, HKMA is not aware of a similar requirement in other jurisdictions. Due to the complexity of products in the OTC derivative market, the Bills Committee has stressed the importance for the proposed regulatory regime to offer adequate protection for investors of OTC derivative products. And they are concerned on how the administration monitors the giving of acts of advising on the OTC derivative products through the media. The administration points out that mainly institutional investors are involved in the OTC derivative transactions. If OTC derivative products are offered to retail investors, they will be governed by the investor protection regime under SFO. As for acts of advising through the media, the journalists and public commentators who do so are not required to be licensed by the SFC. This is to balance the interests of investors against freedom of the press and the rights of journalists to express their views in the media. However, they are still subject to market misconduct and criminal provisions in the SFO. Given that mainly institutional investors are involved in those transactions, SFC does not envisage that advising acts on OTC derivative products through the media would be prevalent. The SFC assures the committee that it is one of the ongoing initiatives to enhance investor education. On disclosure, there are other amendments in relation to requiring electronic filing of notifications and reports on disclosure of interest in listed corporations on the Hong Kong Exchange. Also enhancing criminal courts to make disgorgement orders similar to MMT, for the purpose of recouping illegal gains and loss avoided from committing market misconduct offences, and also enhancing the confiscation regime under OSCO. The Bills Committee supports these amendments in order to enhance the timeliness of publication of potentially market-sensitive information, and also to demonstrate Hong Kong's commitment to fulfilling international obligations to anti-money laundering and counter-financing of terrorism. The administration will propose other amendments to the bill in response to the technical proposals made by market players. The Bills Committee supports these amendments. The Bills Committee will not propose any amendments to the bill and supports the resumption of second reading of the bill. Mr. President, the following is my personal remarks on the bill. After the financial tsunami, there were fluctuations in the financial services industry, and across the world, regulation on the sector have been tightened, and Hong Kong is no exception. And there are new requirements to tighten the regulation and monitoring of the financial market. And this is very important to Hong Kong as an international financial center. In relation to IRS and NDF transactions and swap, etc., settled in renminbi, the information should be kept by the trade repository, and settlement must be carried out in the recognized RCH approved by the Hong Kong Exchange. This is one of the series of reforms. The requirements carry multiple meanings. First of all, the requirement it's helpful in setting up an effective mechanism to fulfill the undertaking made in the G20 commitment, and also the bill requires that all licensed or authorized institutions report the relevant transactions. The existing regulation over asset management, etc., will be expanded. This will help the sector in weathering external fluctuations and also to avoid risks. Now the regulation for OTC derivative market is limited, and the turnover is less than $2 trillion, less than 5% of the total transaction amount. As for our OTC transactions settled in renminbi, which is yet to be freely convertible, it's the amount is even less. We would like to attract major banks in coming to Hong Kong and using Hong Kong as the CCP. This measure will help attract new clients and developing new products. Renminbi is NDF is also commonly used OTC derivative product. Our focus should be on this area. As of December 2013, we have 86 trillion renminbi deposited in Hong Kong, and if we have more renminbi related products, it will help the CNH to increase, and there will be a greater demand for the relevant hedging products. And the Hong Kong exchange will be the first stock exchange to allow OTC derivative products to be settled in Hong Kong, and as the relevant details will be set out in subsidiary legislation. The DAB hopes that the administration can prepare the rules as soon as possible so as to consult the stakeholders and so that they can express their views on the operation of the system. The DAB supports the bill. I so submit.
Does any other member wish to speak? If not, I invite the Secretary for FST to speak. Secretary, please. President, I thank the Chairman of the Bills Committee, Mr. Ka-keung Nam, Bills Committee members, the Secretariat, and the legal advisor for all their effort in completing the scrutiny of the Securities and Futures Amendment Bill 2013, the bill for short. I also thank the Treasury for their support and comments on the establishment of a regulatory regime on the OTC derivative market in Hong Kong. After taking into account the views expressed during the scrutiny, we have introduced certain amendments to address views of the market, to improve the regulatory regime, and to improve clarity of the provisions. I will move a CSA. The global financial crisis at the end of 2008 highlighted the deficiencies in the OTC derivative market. G20 leaders committed to reform the OTC derivative market. All major markets are primed to prepare for the reform. For example, on the 21st of July 2010, the U.S. introduced the Dodd-Frank Wall Street Reform and Consumer Protection Act. In July 2012, the European Union introduced the European Market Infrastructure Regulation. These are legislations to reform the market. The object of the bill is to provide for a regulatory framework for OTC derivative market in Hong Kong in order to meet international requirements. The bill provides for reporting, clearing, and trading obligations that meet the requirements of G20 It also provides for record-keeping obligations that support the implementation of the requirements. In addition, the bill stipulates provisions that regulate essential infrastructure and major participants. The details are set out in the relevant rules, that is, subsidiary legislation. The Hong Kong MA and SFC plan to conduct public consultation on mandatory reporting and record-keeping obligation in subsidiary legislation. The regulatory duty falls on both the Hong Kong MA and the SFC. The Hong Kong MA is responsible for OTC activities of AIs, authorized institutions, and AMBs, authorized money brokers. AIs include licensed banks, restricted licensed bank, and deposit-taking companies. The SFC is responsible for LCs, that is, licensed corporations, and other prescribed persons specified in subsidiary legislation. Under the bill, the mandatory reporting, clearing, and trading obligations apply only to OTC derivative transactions specified in subsidiary legislation. At this stage, we plan to include certain interest rate swaps and non-deliverable forwards in the scope of the regulation. These OTC derivative transactions are those with systemic importance to the local market and can be standardized. Subsidiary legislation will provide for a grace period on reporting and clearing obligations compliance to allow market participants to set up systems to deal with the issues. The grace period for reporting obligation is proposed to be a maximum of 6 months for completion of transactions completed before reporting. Some bodies express their views to the Bills Committee on cross-boundary transaction compliance. We explained to the Bills Committee that while catering for the local circumstances, we strive to bring in line our regulatory system with that of international standards and major markets. Currently, we are having discussions with the European Union and with the US on cooperation arrangements in relation to cross-boundary OTC derivative activities. We also have compliance. We also have measures to facilitate compliance. The Hong Kong MA Trade Repository (TR) is connected with global major TRs. This facilitates the trade to engage global major TRs to report on their behalf to the Hong Kong MA. And local and overseas CCPs, central counterparties, can also be specified under the bill as CCP. In actual fact, that both parties can choose any SFC authorized and specified as CCP. And on top of that, there is the OTC Clearing Hong Kong Limited set up by the Hong Kong EX, which has started offering voluntary clearing service from November 2013. The bill provides for oversight of SIPs, systemic importance participants. These market participants are not regulated by the Hong Kong MA or SFC, but their positions and activities in the OTC derivative market are so large that they may raise concerns of potential systemic risks. If their OTC derivative positions reach certain thresholds specified in the subsidiary legislation, they should notify SFC, so Hong Kong regulators can have oversight of these SIPs and monitor their activities to see if they may harm our financial system. The Bills Committee studied the assessment criteria of SIP threshold. The SFC has considered the views expressed by the sector and decided to adopt a quantitative approach and not something that is not quantifiable. so that the market participants will find it easier to understand and enable efficient notification. The Hong Kong MA and the SFC will consult on the SIPs. Will consult the public on SIP notification. The bill also includes 2 new RAs, regulated activities. The new Type 11 RA covers activities of OTC derivative products dealers and advisors. New Type 12 RA covers activities of persons providing client clearing services. Existing Type 9 RA and Type 7 RA will be expanded. These Type 9 RA covers asset management. It will be expanded to cover OTC derivative portfolio. Type 7 RA covers ATS, automated trading service. It will expand to cover OTC derivative transactions. The bill provides for transitional arrangements for new and expanded RAs to allow serving intermediaries providing services in the OTC derivative market to continue their business for a limited period of time. The Bills Committee discussed various measures to reduce the impact of the new and expanded RAs. According to the views collected during the public consultation, we are aware that the public would like to have a longer transitional period. We have already put in longer application period and transitional period under the bill, and they are 3 months and 6 months respectively to facilitate transition to the new regime and to reduce the impact on existing businesses. A person who submits an application to be licensed for any of the new or expanded RA and meets certain qualification criteria will be deemed to be licensed at the expiry of the transitional period until SFC completes the application process. Once notification is given, the applicant can continue with the RA. To ensure that the Hong Kong MA and SFC will have corresponding regulatory powers, the investigatory and disciplinary powers of the SFC will be expanded to cover OTC derivative activities. Similar powers will be given to the Hong Kong MA to ensure compliance of AIs and AMBs. In order to provide an environment with fair competition, the bill empowers the Hong Kong MA. This power will be in line with the investigatory and disciplinary powers under the SFO, the Securities and Futures Ordinance. Part 3 of SFO contains insolvency override protections, which aim to prevent transactions cleared through RCH recognized clearinghouse from being unraveled by the application of insolvency law in the event of default by any of the RCH members. These protections are crucial because of the potential domino effect that any such unraveling might otherwise have on other members of the RCH. Currently, these protections only apply to arrangements and agreements between RCH and its members in respect of default of an RCH member. The bill amends Part 3 of the SFO to extend the application of default rules of RCH and the coverage of the insolvency override protections. The amendments aim at extending the application of insolvency override protection to default of RCH and certain client clearing arrangements of RCH supported OTC derivative transactions. With the amendments, client positions and collaterals will not be used to repay creditors in the event of default of an exchange participant. The assets will be ported to another RCH member who is willing to take them up. or else liquidated by the RCH with remaining collateral returned to the client. The Hong Kong EX has put forward submissions on the relevant provisions and proposed technical amendments to the regulators. We have adopted their suggestions, and the amendments are supported by the Bills Committee. The bill also implements other improvements to the regulation of the financial market. First, the bill amends the SFO to require electronic filing of notifications and reports on disclosure of interests under Part 15 of SFO in order to enhance timeliness of publication of potentially market-sensitive information. On market misconduct offences, the bill amends the SFO to extend the coverage of disgorgement orders made by a criminal court to profit, gain, and loss avoided. This is similar to the fining power of MMT, Market Misconduct Tribunal. Amendments are also made to the Organised and Serious Crime Ordinance to empower a criminal court to make restraint orders, charging orders, or confiscation orders in market misconduct offences to freeze, seize, and confiscate proceeds from or instrumentalities used in money laundering or predicate offences. This will meet the recommendations of the Financial Action Task Force. All in all, the bill will help Hong Kong set up an effective regime to regulate OTC derivative market and fulfill the obligations of G20 and bring us into a par with other financial centers. The bill and the proposed amendments are supported by the Bills Committee. I ask members to support the bill and the amendments. And I'll put the question to you, and that is, the Securities and Futures Amendment Bill 2013 be read the second time. Will those in favour please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Securities and Futures Amendment Bill 2013.
Committee stage. Council is now in committee. I now propose the question to you, and that is that the following clauses stand part of the Securities and Futures Amendment Bill 2013. Clauses 1 to 8, 10 to 13, 15, 16, 17, 19, 21 to 36, 38, 39, 41 to 51, 54, 56, 59, and 61 to 69. Does any member wish to speak? And I'll put the question to you. And will those who are in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Clauses 9, 14, 18, 20, 37, 40, 52, 53, 55, 57, 58, and 60. Secretary for Financial Services and the Treasury. Chairman, I move the amendments to the clauses read out just now. And the amendments are contained in the agenda issued to members. I move an amendment to revise Clause 9 of the bill. The purpose is to introduce the mandatory record-keeping obligation and to empower the Chief Executive in Council to make rules concerning the Hong Kong MA's charging of fees for the trade repository. The amendment will introduce the obligation to mandate record keeping so as to assist the discharging of the obligation in relation to reporting, clearing, and trading, so as to make sure that the prescribed persons can keep adequate records to prove compliance with the various mandatory obligations. This means that the regulators may obtain those records to assist with the discharging of their regulatory functions. Like other mandatory obligations, the details concerning record keeping will be contained in the rules, that is, subsidiary legislation. We have already carried out initial consultation with the industry. We understand that they do not object in principle, and we are going to consult the public in the second quarter. Moreover, the amendment also empowers the Sitting Council to do the following after consulting the Hong Kong MA, that is to make rules concerning the charging of fees concerning the trade repository. We intend to carry out consultation in the second quarter of this year, that is to be done by the Hong Kong MA. And to respond to market opinions, the amendment will provide for the following. Breach of the mandatory obligations will not affect the validity and enforceability of the transactions unless the parties to the transaction have expressly agreed otherwise. This is consistent with the approach adopted in the EU, Australia, and Singapore. We also more clearly provide for the scope concerning the systematically important participants, the positions of SIPs, as well as the penalties for breaching the notification obligation. I also move an amendment to amend clauses 53 and 55 so as to amend the provisions concerning the new and expanded regulated activities so that the provisions are clearer in order to avoid confusion or overlapping in relation to the RAs. In addition, I would like to move an amendment to clauses 52, 57, 58, and 60. The Hong Kong Exchanges and Clearing Limited made a submission to the Bills Committee concerning the related provisions. Later on, they also made a proposal to the regulators concerning the technical amendments. We've taken on board the recommendations so as to clarify the meaning of certain terms, and we've also improved the relevant provisions so as to better provide for the insolvency override protection provisions after expanding the scope of protection. As to the other amendments, they are in relation to clauses 14, 18, 20, 37, and 40 of the bill. They are all consequential amendments or to make sure that the provisions are clearer and more easily comprehensible. The Bills Committee agrees with the CSAs proposed by us. I urge members to support the amendments. Thank you. Does any member wish to speak? And I'll put a question to you as stated. That is, the amendments moved by the Secretary for Financial Services and Treasury be passed. Will those in favor please raise their hands? Those against please raise their hands. I think the question is agreed by a majority of the members present. I declare the amendments passed. Clauses 9, 14, 18, 20, 37, 40, 52, 53, 55, 57, 58, and 60 as amended. And I put a question to you, and that is that clauses 9, 14, 18, 20, 37, 40, 52, 53, 55, 57, 58, and 60 as amended stand part of the bill. Will those in favor please raise their hands? Those against please raise their hands. I think the question is agreed by majority of the members present. I declare the motion passed. New clause 58A, section 45 amended. Proceedings of recognized clearing house take precedence over law of insolvency. Secretary for Financial Services and the Treasury. Chairman, I move the second reading of the new clause 58A. As set out in the paper sent to members, we have taken on board the recommendation from the Hong Kong Exchanges and Clearing Limited so as to amend Section 45 of the SFO to expressly include reference to the provision of market collateral so as to ensure that market collateral provided by way of an outright transfer rather than by way of a charge is also covered by the insolvency override protection. This is a technical amendment. The purpose is to improve the protection afforded by insolvency override protection so as to make sure that market collateral by way of direct transfer will not be used to repay creditors. The Bills Committee support the new provision. I urge members to support the motion. Thank you. I now put a question to you, and that is that the new clause 58A be read the second time. Does any member wish to speak? And I'll put a question to you as stated. Will those in favor please raise their hands? Those against please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. New clause 58A, Secretary for Financial Services and Treasury. Chairman, I move that the new clause 58A be added to the bill. I now propose the question to you, and that is the new clause 58A be added to the bill. And I'll put the question to you as stated, and Those who are against, please raise their hands. I think the question is agreed by majority of the members present. I declare the motion passed. Council now resumes third reading, Securities and Futures Amendment Bill 2013, Secretary for Financial Services and the Treasury. President, the Securities and Futures Amendment Bill 2013 has passed through the committee stage with amendments. I move that this bill be read the third time and do pass. I now propose the question to you, and that is that the Securities and Futures Amendment Bill 2013 be read the third time and do pass. Does any member wish to speak? And I'll put the question to you as stated. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Securities and Futures Amendment Bill 2013. We now resume the second reading debate on the Loans Amendment